Hello, welcome back. Today we will speak about the community of international courts in present-day international society, with a special focus on the international courts present in The Hague. We have seen in the previous videos that the ICJ and its predecessor, the PCIJ, originate in a desire to confront war and to provide a way for states to solve their conflicts in a non-violent way. Yet, the system of dispute settlement, as it was designed throughout the 20th century, might merit fresh reflection in our new century and in our increasingly complex world. For instance, the early 20th century international law system was based on the idea of peaceful coexistence between states, with the ultimate aim of banning war. However, throughout the 20th century, there has been increased cooperation between states that goes beyond peaceful coexistence. States have started to cooperate to protect global values other than peace, such as the environment, human rights and global health. Now, are these matters that the World Court can also protect, or do we need new international courts for this? In addition to having international courts take on new roles, the customers of their services have also diversified. The traditional system of international justice, as described in previous videos, was very much geared towards states. But what about new actors in the international society, such as multinational corporations, armed opposition groups, individuals? Do they also have a court to turn to? Should they have? Indeed, as the international legal system has become more complex, the international judicial landscape has also changed. In fact, ever since the end of the Cold War, we have witnessed this emergence of a new judiciary, the establishment of new specialized international courts and tribunals. These include the International Tribunal for the Law of the Sea in Hamburg, regional human rights courts, regional economic courts, and international criminal courts and tribunals. This development is also called the Proliferation of international courts and tribunals. In this MOOC, we are focusing only on the Hague International Courts. We will zero in on the ICJ in Module 2, and on the PCA and arbitration more generally in Module 3. Apart from these two institutions, The Hague has become known as the city hosting most international criminal courts and tribunals, including the Yugoslav Tribunal, the Appeals Chamber of the Rwanda Tribunal, the Special Court for Sierra Leone, which heard the case against Charles Taylor in The Hague, and the Lebanon Tribunal, and of course also the International Criminal Court, also called the ICC. Module 4 will discuss all the criminal tribunals with a focus on the ICC. And then you will come to realize that the international courts and tribunals that we discuss in all these modules are very different in kind. For instance, whereas the ICJ is strongly state-centered, arbitration is also open to non-state actors such as armed opposition groups. An example of this is the arbitration between the government of Sudan and the Sudan People's Liberation Movement. Moreover, investment arbitration is open to private investors, including multinational corporations. International criminal courts, in turn, are focused on individuals that have been involved in genocide, crimes against humanity, or war crimes allegedly. So we see that actors other than states can indeed be involved in international proceedings in The Hague. Many of the courts and arbitration arrangements that we will zoom in on in this MOOC are permanent. The ICJ, the PCA and the ICC. They are also universal in the sense that they are open to all states from whatever region. As we will see though, this does not mean that they can always exercise their jurisdiction. This often depends on the extent to which states have consented to their jurisdiction. In the international judicial landscape, we can also find ad hoc courts with more limited geographical jurisdiction, like the International Criminal Tribunal for the former Yugoslavia. Interestingly, this court, which was established by the UN Security Council, does have compulsory jurisdiction, which means that states have an obligation to cooperate, and that it can impose its binding decisions and that there is no need for any further state consent. So what is important to realize is that international courts and tribunals exist in a range of different shades and colors. They can be permanent or temporary, universal or regional. They can have mandatory jurisdiction or not. They can be designed to deal with a specific type of conflict or dispute or a specific area of law or not. And they can focus on different actors in international law, states, individuals, corporations, and armed opposition groups. We will guide you through these differences so that you will be able to differentiate between the international courts and tribunals and to know what can be expected of each court. Here are some questions that you will be able to answer after watching our entire MOOC. Firstly, if the ICJ was called the World Court in the 20th century, is the ICC the new World Court in our 21st century? Inherent to this question is a deeper question which reads, is international criminal law actually the best and most effective way of dealing with conflict? We are not so sure, but we look forward to discussing this with you. Changing perspective away from the ICC to the PCA, is the PCA the ICJ's main competitor? And what future is there for arbitration more generally? Given the rise of terrorism and terrorist groups, should we establish an international terrorism tribunal? Here again, we would like to enter in debate with you about the potential, but certainly also the limits of international courts. We look forward to these debates.